330,000 applications a year. That is the scale the Justice Department says this new federal firearms rights restoration program could eventually face. But that number needs to be understood correctly. It does not mean 330,000 people are automatically getting their gun rights back. It does not mean federal firearm prohibitions are disappearing. And it does not mean state gun laws are being overridden. What has changed is something much more specific. For the first time in decades, the federal government is putting a functioning process behind a provision of federal law that has largely existed without a practical way for people to use it. The Justice Department has finalized a rule establishing a formal process under 18 U.S.C. Section 925C, allowing certain people prohibited from possessing firearms under federal law to apply for relief from that federal disability. Section 922 Ging remains in place. The prohibitions remain, but eligible applicants will have a pathway to ask the federal government whether those restrictions should continue to apply to them. And that pathway was not invented by this rule. Congress had already created it. Section 925C allows a prohibited person to apply for relief, but the statutory standard is demanding. The Attorney General must determine that the circumstances surrounding the firearms disability, together with the applicant's record and reputation, demonstrate that the person is not likely to act in a manner dangerous to public safety and that granting relief would not be contrary to the public interest. The mechanism existed in law. The practical ability to use it largely did not. Beginning in 1992, Congress prohibited ATF from using appropriated funds to investigate and process Section 925C applications. The statute remained on the books, but the agency responsible for administering the process could not spend its appropriated budget doing the work. In practical terms, the restoration mechanism became largely unavailable. The old ATF process had also faced criticism. Investigations could be resource-intensive, determinations could be inconsistent, and Congress believed ATF personnel should be spending more of their time investigating violent crime rather than processing firearms rights restoration applications. That produced an unusual situation that lasted for more than 3 decades. Federal law said relief could be requested, but the federal machinery needed to evaluate those requests was effectively shut down. That is the problem the new rule is designed to address. In March 2025, Section 925C authority was withdrawn from ATF. In July 2025, DOJ proposed criteria for a new restoration program. Now the department has moved from proposal to final rule, with the new process operating through the Attorney General rather than simply resurrecting the old ATF system. But this is where the details become critical. There is no automatic restoration. Completing a sentence does not automatically restore federal firearm rights through this program. Waiting a certain number of years does not automatically restore them either. DOJ specifically rejected proposals that would have created automatic restoration after completion of a sentence or after a fixed period of time. Every applicant has to make an individual case, and the Justice Department can examine a remarkably broad range of information when deciding whether that case satisfies the statutory standard. Criminal history is only the beginning. DOJ may consider arrests that never resulted in charges. It may consider charges that never resulted in convictions. It may review deferred prosecutions, dismiss charges connected to plea agreements, the seriousness of previous conduct, compliance while serving a sentence, how much time has passed since that sentence was completed, substance abuse, restraining orders, threats or threatening behavior, mental health information, and information submitted by law enforcement officials where the applicant lives. The application requirements reinforce just how extensive that review can become. Applicants must identify the federal firearms prohibition that applies to them and authorize DOJ to examine records concerning their background, including employment, medical history, military service, and criminal history. Individual applicants must submit fingerprints. For someone applying because of a felony conviction, the documentation burden becomes even heavier. The applicant may need records directly connected to the conviction, potentially including the charging document, a plea agreement, the factual basis for the plea, the present tense report, the judgment, and documentation showing that the sentence was completed. For someone whose case happened years ago, that can mean reconstructing a substantial paper trail before DOJ can fully evaluate the application. And the records do not necessarily stop with the jurisdiction where the conviction occurred. Applicants must obtain criminal record checks from every state in which they have lived since turning 18, or during the previous 25 years, whichever period is shorter. Where statewide records are unavailable, local records may be required instead. The same requirement applies to jurisdictions where the applicant has been arrested during that period. Then come the character references. Every applicant needs 3. Those references cannot be related to the applicant by blood or marriage, and they must have known the applicant for at least 3 years. These are not simply letters saying someone is a good person. The references must make statements under penalty of perjury concerning the applicant's conduct, character, and potential risk. Among other things, they must attest that the applicant is not an unlawful user of controlled substances, does not regularly abuse alcohol or other intoxicants, is of good character and reputation, has not threatened unlawful violence or attempted suicide during the previous 5 years, and would not pose a danger to public safety, themselves, family members, or intimate partners if allowed to possess a firearm. The applicant must make similar affirmations under penalty of perjury. Taken together, those requirements show what DOJ is actually trying to determine. The department is not looking only at the legal name of a conviction. It is looking at what happened, how long ago it happened, what the applicant has done since, whether additional warning signs exist, and whether the person's current record supports the conclusion that restoring federal firearm rights would be consistent with public safety. But even a complete application does not put every applicant on equal footing. The rule creates a series of presumptions that can make relief substantially harder for certain categories of people. For a long list of serious offenses, DOJ says applications will be presumptively denied unless extraordinary circumstances exist. Those categories include felonies involving death, rape, sexual abuse or assault, human trafficking, kidnapping, domestic violence, burglary, robbery, extortion, carjacking, arson, certain racketeering offenses, gang-related offenses, assault, battery, stalking, escape, terrorism, and witness tampering. The presumption can also apply to other felony offenses where a firearm was brandished or discharged or an explosive was used during the crime, as well as attempts, solicitation, conspiracy, or aiding and abetting involving those offenses. For other applicants, time becomes one of the major barriers. Certain offenses carry a 10-year presumptive period. Those include certain drug trafficking crimes, threats of violence, explosive offenses, specified federal firearms offenses, possessing or discharging a firearm or weapon on school property, and animal abuse. Misdemeanor domestic violence convictions also generally carry a 10-year presumptive period, with additional provisions that can restart the clock based on subsequent conduct. Then comes one of the most significant provisions for people with other felony convictions. For other felonies, the presumptive period is 5 years. But that does not simply mean 5 years from the date of conviction. The rule looks at whether the applicant has, within the previous 5 years, either been convicted of another felony or served any portion of a sentence for another felony. That distinction can completely change when someone has a realistic opportunity to apply. DOJ says applications involving someone who satisfies the timing requirement and has only one prior nonviolent conviction are likely to be comparatively straightforward and may therefore be processed relatively quickly. There are also status-based presumptive disqualifications. Those include people currently awaiting sentencing, currently serving any portion of a sentence, participating in certain diversion programs, certain fugitives, certain prohibited aliens, people subject to qualifying restraining orders, certain unlawful users or addicts of controlled substances, and certain registered sex offenders. But one change inside that category stands out. The final rule specifically excludes people whose only unlawful controlled substance use or addiction involves marijuana from that particular status-based presumption. DOJ says the change reflects both a Supreme Court decision from this year and comments received during the rulemaking process. That does not mean marijuana becomes irrelevant to every application. It means that marijuana-only circumstances do not automatically place an applicant into that specific presumptively disqualified status category. And that distinction points to something broader about the rule. A presumption can make relief much harder. It does not necessarily make relief impossible. DOJ retained what amounts to an escape valve for cases involving what the regulation calls extraordinary circumstances. The department declined to create a rigid definition of that phrase. Instead, it identified factors that may be relevant, including the seriousness of the original offense, the applicant's age at the time, remorse and atonement, and an exceptionally long period without subsequent criminal conduct. The rule even provides an example involving a burglary conviction based on an unarmed entry into an abandoned building, where the underlying conduct might plausibly have supported a lesser trespassing charge. The conviction still matters. The presumptive category still matters. But DOJ is leaving room to examine whether the formal label attached to the conviction tells the entire story. That is, individualized review. And there is another provision that makes the constitutional dimension of that review explicit. The Attorney General may consider whether an applicant's individual circumstances demonstrate that failing to grant relief would infringe the applicant's rights under the Second Amendment. That does not guarantee restoration. It does not override the statutory public safety standard. But it places the Second Amendment itself directly inside the decision-making framework. The process is also being built as a formal administrative system. The Justice Department says an online portal will be launched to accept applications while the Pardon Office prepares the process and information applicants will need. Applicants will need to assemble records, fingerprints, references, and other supporting materials before their cases can be evaluated. The proposed application fee was $20. The final rule raises that fee to $30. DOJ says applicants may request that the fee be reduced or waived because of indigency. But the filing fee is only one part of the practical burden. Fingerprints, court records, criminal history checks, and other documents can create additional cost and additional work. Then comes the number that reveals how large DOJ believes the program could become: 330,000 applicants per year. Again, that is an estimate of applications, not approvals. DOJ estimates that each application will require about 65 minutes of applicant response time, in addition to the work performed by the 3 character references and the time and expense involved in collecting fingerprints and records. At that scale, this could become a substantial federal administrative program. And when relief is granted, the decision will not simply remain inside an internal file. DOJ says notice of the action and the reasons for it will be published in the Federal Register. But an approval comes with one limitation that every applicant needs to understand. This process restores federal firearm rights. It does not automatically erase an independent firearm prohibition imposed by a state. The regulation says that a person granted relief will be relieved of the applicable Federal Gun Control Act disability concerning the acquisition, receipt, transfer, shipment, transportation, or possession of firearms or ammunition. That is federal relief. But federal relief and state relief are not the same thing. If state law separately prohibits that person from possessing a firearm, the federal government's decision does not erase the state prohibition. That restriction would have to be addressed separately. So, a person could successfully convince the federal government that the federal disability should no longer apply and still remain prohibited from possessing a firearm under state law. There is another boundary as well. If someone receives federal relief and later commits another offense that creates a new federal firearms disability, the previous restoration does not protect that person from the new prohibition. The new disability would have to be dealt with on its own. The rule is therefore not a permanent immunity. It addresses the federal firearms disability for which relief has been granted. And that brings the story back to where it started. For more than 30 years, federal law contained a provision allowing prohibited individuals to seek restoration of federal firearm rights, while the practical mechanism needed to process those requests was largely unavailable. The new rule is designed to make that mechanism operational again. Not automatic, not universal, and certainly not easy, but operational. For someone with an older nonviolent felony conviction who has completed a sentence, remained out of serious trouble, satisfied the timing requirements, produced the required records and references, and demonstrated that they do not pose a danger to public safety, there will now be a process through which the federal government can evaluate whether continued federal disarmament remains justified. And that leads to the principle underlying the entire rule. DOJ says a person may have engaged in conduct that constitutionally permitted the government to disarm that person at one point without necessarily remaining permanently and completely outside the protection of the Second Amendment. The department puts the principle this way. The Constitution sets a floor for the protection of Second Amendment rights, not a ceiling. That sentence explains why this process is more significant than a new application form. The conviction matters. The conduct matters. Public safety matters. The applicant's later record matters. And in some cases, the constitutional cost of continuing the prohibition may matter as well. The rule does not erase what happened in the past. It creates a process for determining whether what happened in the past still justifies the same federal restriction today. For applicants with serious violent histories, recent criminal conduct, current disqualifying status, or other major risk factors, the barriers remain substantial. Some begin with presumptions against relief. Some face 10-year periods. Others face 5-year periods. Every successful applicant must still satisfy the statutory standard governing public safety and the public interest. But permanent federal prohibition is no longer the only practical outcome simply because the restoration mechanism itself cannot function. There is now another question the government can actually evaluate. Has enough changed to justify relief? The answer will depend on the individual case. And even when the federal answer is yes, state law may still say no. That federal-state boundary remains intact. The final rule becomes effective 30 days after publication in the Federal Register, and DOJ says it will begin soliciting applications at that time. That is when the rule moves from a 144-page regulation into individual cases. Applicants will submit their records. DOJ will examine criminal history, conduct, timing, references, risk, and the circumstances surrounding the original disability. Some applications will confront presumptive denial. Some may present extraordinary circumstances. Some cases involving an older, single, nonviolent conviction may be relatively straightforward. Others may never satisfy the standard. But after more than 3 decades in which the federal restoration mechanism was largely unavailable in practice, one thing changes decisively. There will once again be a functioning process through which eligible individuals can ask the federal government to determine whether their federal firearms disability should continue. Not blanket restoration. Not automatic restoration. A case-by-case pathway to federal relief. And that distinction defines the entire rule.